take maybe 2 or 3 questions very quickly. So, last October, on the 23rd, Justice Madlanga issued directions regarding the use of cameras, and that applies both to stills and for broadcast. I want to take you through that so that you are clear and hopefully understand it. It's fairly simple, so I'm going to read through it. 1, cameras must not capture or transmit any images of the screens of electronic devices belonging to or being operated by Commission staff. So in other words, in the front benches here, there are legal representatives of the Commission and of the witnesses. You are not to look at their screens or take any pictures or broadcast any pictures of those laptops, tablets, or cell phones, and that includes the commissioners up here, and of course, that includes Justice Madlanga. Then only content which is projected by the Commission on the large 1, 2, 3, 4 TV screens inside the auditorium may be captured for broadcast or publication. So in other words, if there is evidence to be flighted here during proceedings, it will be flighted there. And that is the only public evidence that is available to yourselves as the media to project, to broadcast or print. And then thirdly, all media are requested to take particular care in ensuring that they do not publicize information which is not expressly intended for public consumption. I think that speaks for itself. All right. We appreciate all of you and the role that you play, members of the media. Are there any questions? None? Going once? Going twice? All right, looks like we're all good. Please make sure that you don't cross the red lines. The seating for media is clearly designated. Of course, the photographers, we know, may want to move around a little bit. Please make sure that you do so quietly if you do. Don't disturb the proceedings, don't distract the team here in front. But yeah, feel free to do your jobs as you see fit within those confines. Thank you. 9:29. We start at 9:30. Please ensure, listen to me carefully, please ensure that your cell phones are off. We don't want them to disturb the proceedings. Make sure that they are either off or on silent. Thank you.
Good morning, Mr. Law. Good morning, Ms. van der Heever. Good morning, Mr. Matlala.
Good morning, Chairperson. Good morning, Commissioner.
Please pull the mics closer to you and switch both of them on.
Morning, Chair, and morning, Commissioners.
I greeted you and your mic was off. Good morning.
Good morning once again, Commissioner.
Thank you.
Thank you, Chair. Chair, Commissioners, you'll recall that Mr. Matlala had been subpoenaed to appear on the 7th of July, 2026. And on that date, Mr. Matlala's legal representative and I presented ourselves before you, and we had an engagement, the outcome of which was that Mr. Matlala's appearance was postponed to the 15th of July. Today, and the commissioners issued a ruling in that regard and on some other aspects. Mr. Matlala is present. We are back before you, and Mr. Matlala's legal representatives would like to address you, Chair. The issue about which she is about to address you is contained in the folders that have been made available to you, but I will leave it to her to take the commissioners through the contents of that folder. Thank you.
Ms. van der Heever.
Good morning again, Chairperson, Commissioners. We have prepared for your benefit and in support of our application for a postponement an affidavit that was duly deposed to by our client. Due to time constraints, however, we were only able to last night email an unsigned copy to my learned friend. The situation was that for a variety of reasons this could not be done earlier. I would like to very briefly, if it's necessary, Chairperson, Commissioners, just take you through our reasoning as to why we respectfully submit that a postponement in this matter should be granted.
Is there a signed affidavit now?
There's indeed a signed. It was commissioned this morning, and we thank the Commission's, my learned friend and her team for assisting us with that. Even at, I think, at 10 o'clock, there was another endeavor made to get it signed at the prison. There were some arrangements, but it just came to no fruition.
I do see it in a small folder in front of me. I read from my laptop, and that was an unsigned version. Thank you, thank you.
Chairperson, in short, we set out the history of what's transpired vis-a-vis Mr. Matlala, when he was arrested, how the events surrounding him has unfolded. And the most important aspect thereof is the fact that he's due to commence with a trial on Monday. We believe that he's got the constitutional right to attend this trial and be regarded as innocent until proven guilty, together with the other constitutional rights that we've dealt with in this particular affidavit. We respectfully submit that for him to deal with some of the issues, which issues play a very big part in the up-and-coming trial that starts in 4 days, would violate his constitutional right to actually challenge the evidence. We've indicated to you, for instance, that both witness C and Lieutenant General Nkomazi relied on a statement that was given to them by Mr. Matlala.
Before you get to that point, let me ask a general question. Is the submission that a person required to appear before a commission, but who also happens to be facing criminal charges, can never ever testify before a commission prior to the finalization of the criminal proceedings?
May it please you, my respectful submission is, if I read, I've quoted for you from Justice Jafta's decision in the Zuma matter, and it's quite...
That was a minority judgment.
Yes, but still, I would respectfully submit, with the greatest of respect, Chairperson, that where you have constitutional rights, that those constitutional rights, especially in the very unique situation that my
You
client...
see, I'm raising the point that that was a minority judgment to understand on what basis you can then rely on that dictum or on that legal statement to suggest, in response to my general question, to suggest that a person who is facing criminal charges can never ever testify before a commission of inquiry.
I respectfully submit that when you have a person that's either an accused or a suspect, I respectfully submit that your constitutional rights, with the greatest of respect, override the compulsion that there would be from the commission side for him to give evidence. He would literally forego a large number of his rights if he is compelled to give evidence under those circumstances. I think what we've done, if you would just permit me, please, Chairperson, I think...
No, I just moved my shoulder.
Yeah.
I did not say anything.
No, I think respectfully, what I've endeavored to show to you...
You know what we always say in the legal profession, both amongst legal practitioners and people presiding, that when counsel says respectfully, they actually mean the opposite.
I was told that many years ago by a good friend that presided over a trial where he said, that was the impression. But I
sorry for interrupting you. I'm sorry. Yes, please.
I fully understand.
Yes.
The point is that is the nearest that we could come to any authority on this point. And this issue to us was so important that we were going to try and see if we could actually deal with this matter, if necessary, elsewhere. Where we are right now, I respectfully submit, we don't have to go there.
Where is elsewhere? Is it a court application?
Yes. No, only the approach would have been to actually make, if the matter were to continue, to make the necessary full-blown legal argument and submissions to you, and then depending on your findings to take it on review. I'm honest, I've indicated that to my learned friend before too. It's because we so strongly believe that your constitutional rights, where the Constitution is the most important document in this country, those rights cannot be taken away from you by a commission who's got a certain mandate and who's, to quote my learned friend, on a fact-finding exercise. And more so, I think what we've done, Chairperson, we tried to set out to you why we believe that the constitutional rights, especially in this case, overrides what, and we're not fighting with what our client is duty-bound to come and do at the commission. What we say is, so far you've heard one side of the coin. This side of the coin that you heard, and you see, don't want to go into the details. As we said, we don't want to give away our litigation privilege in that regard. If we run our trial, we will show to you that what you've heard potentially is either not the truth or unlawfully obtained, etc. And for that reason, we will, at the end, of course, also assist the Commission in finding the truth in this, what I respectfully say is a quagmire of facts that you have to deal with. That is the one issue.
Or may I, before you go to the next issue, a difficulty that I have, and that of course is subject to your response, is that this is raised or this is being raised in a blanket fashion is the suggestion that any and everything that Mr. Matlala could ever say before this commission would be something that would be subject to the exercise of his Section 35 right? Is that what's being suggested? And that there is nothing whatsoever that he could ever say which would be unaffected by his Section 35 right? Is that what's being suggested?
That is not what I'm saying, and
If-
I think I've made that quite clear when I discussed with my learned friend. The difficulties that we find ourselves in at this point in time, and that was also the issue that prevented us from actually dealing with any affidavit beforehand, is that our client, and I was not party to that particular agreement, I only came in later, through a different legal representative with IDAC, the gentleman that's been named here was part of that, entered into to a 105A plea agreement. The magistrate then came back and found that the sentence wasn't just and therefore gave all the parties time to go and reconsider. The issue that's when I got briefed to come back in, because there were very material and important issues that were not raised in the 105A that we believe would have materially influenced potentially the outcome of such an agreement. The only time that matter could be dealt with, or the issues that was raised at that point, and if you bear with me, I have to choose my words carefully at this point because it's a very difficult situation, was when the magistrate finally made a ruling. So past Monday, that is 2 days ago, he actually, in terms, I think it's a 105 capital A 9B Roman 2, if I'm correct. He actually said, well, he asked the state, what is your contention? The state said, oh, we wish to continue. He asked us and we said, no, we assail from the agreement. What then happens in terms of the Criminal Procedure Act is that it's as if there was never any plea negotiations happened. The issue for me is, and this is where I want to answer your question, Chairperson, is we were not involved in those negotiations. We know what transpired and under what circumstances in those negotiations. It doesn't take somebody to be a genius to having regard to what one's now learned, for instance, on Friday, what happened there. And my attorney and myself made the decision that we are not prepared to deal with any of these questions until such time as we are provided with the notes as to what transpired during these negotiations, as well as potentially any other documents that were drafted and signed. Because from the say-so that we've heard, it impacts on a lot of the questions we were asked to answer. And we are not prepared to just on somebody say, okay, we now exercise our Section 35 right on this and this and this. We want to come here as officers of the court, properly advising our client how that these are questions that you have to answer. You're compelled to answer them. You can't, let's say, invoke Section 35 rights. And as we sit here, Chairperson, we still can't give you an answer to that question because we still don't have that. So there is, of course, and that is the long and the short of it, there is answers that you can answer. But at this point, I can't come to you as an officer of the court in honesty and say to you, okay, this is my instructions. I need to, because of this quagmire of IDAC's involvement, be sure that what we say to you is truthful, because there's also the penalty of perjury, and of course there's a previous inconsistent statement that can be raised at any stage. So for that reason alone, I agree with you. There are issues, of course, you can never assail your compulsion to answer to those. But until such time as we can present to this Honourable Commission an affidavit that we satisfied contains, is based on facts and where we can invoke that right correctly, I cannot even go as far as to say, we don't know this person. For instance, I could have come to you now because I know from the list, Annexure A, we could give you a list and say we don't know these people. But for the rest, it's not in your interest that we present, in your, and I mean the Commission, the Royal U, interest that we present in piecemeal fashion answers to questions. The fact of the matter is that my client has been made out to be this mastermind by everybody. And we respectfully, from our interaction, say that there's a fallacy in that. And we intend to show...
Please tell me when you are done with
Yeah.
responding to my question.
Yeah.
Before you move on to another
I've
point.
basically responded to your question.
Thank you. Let me tell you how my difficulty arose. It's because the affidavit does not clearly delineate the issues either at all or as clearly as you have done now. And that is because, for example, the application says the entire commission process must be postponed pending finalization of the criminal process. So it's on that basis that I then ask you, does that mean there are no questions whatsoever that Mr. Matlala could deal with before this commission? Now you have responded and said, no, there are. So there are issues that he can deal with before this commission. Now my next question is, why can't that happen before the criminal process has been finalized?
Because I, as an officer of the court...
At this level, just...
I'm honest with you.
No, let me finish. At this point, focusing only on those, this of course is not a ruling on whether we agree on the Section 35 point. That's something we're still to apply our minds to. But focusing only on the issues that can be carved out of the Section 35 issues. Why can't those be heard or dealt with by this commission before finalization of the criminal process?
So there's three reasons. The first I've already dealt with. I said to you that there was negotiations ongoing and I need to understand in those negotiations who, what and where. And without that, I cannot,
Are you talking negotiations
with IDAC,
relating to the plea deal?
relating to the plea.
That's history now. I'm asking
No,
you about now. I'm
it's-
asking you about now,
It's
please.
not history because it's only if I have regard to those and those are handed over that I can come and say I can answer question A and B but not C and D, because it is clear from what we have been given that is a suspect on these issues. So you cannot answer that question. So that is my first point. I cannot at this point in confidence say to the Commission, and I won't permit my client to deal with those until such time as I know what they have negotiated with him, what they've asked him, what he's committed to, what he's not
But
committed to.
is that not an issue relating to whether there should or shouldn't there be a postponement? And that's not what I'm asking you about.
No, sir,
I'm asking you about the precedence.
Yes,
Which of the two processes must precede the other? So I understood you to be referring to the plea deal in the context of saying, prior to that being finalized, I do not know what to do. I must wait until the end.
No.
That's something else altogether.
No, that's not what...
It has nothing to do with whether. Once the plea deal is dead and buried, must the commission process wait for the criminal process? So the earlier issue, the plea deal, is finalization or even non-finalization has nothing to do with the question I'm putting to you.
It does indeed, Commissioner. If you will permit me just to explain to you.
All right.
During a plea deal, there is much more than the simple wording in the plea deal that takes place. There's other negotiations that happens between the investigators, the client and the attorney. And during those investigations, there's names that come up, there's information given, etc. And during that negotiations, a person potentially is, and I'm trying to keep it in the abstract, is told, you are a suspect on this matter. Let's say you're a suspect that you connived with General X to do A, B, and C. General X doesn't appear, for instance, in the plea deal. It's discussed there, there's questions made, there's recordings made, but General X appeared in the Regulation 10.6. Now, for me to deal with whether he's a suspect or not, in respect of anything to do with General X, I need to know what was discussed during the plea negotiations. And it's not just somebody sitting there and now we're drafting a 105A.
For what purpose? You are doing that for what purpose?
For purpose of invoking my right to silence on that. I can say,
No,
I've been
then
told...
you don't get me altogether. Then you don't get me altogether. We have already, please listen to me. We have already made common cause that there are issues in respect of which Mr. Matlala is able to deal with before this commission. Now, you are talking about issues that, post the plea deal, may also fall under the Section 35 dispensation that you are claiming. I have said, let's put aside all of that. So what you are telling me falls, according to you, under that basket. I have said, let's put that aside. And let's address our minds to those issues about which there is no question. Regarding them being heard by this commission. That is what my focus is on. And it's on that basis that I say to you, I do not understand your point about the plea deal and its relevance to my question. I hope you get me now.
Let me again try and explain to you, Commissioner, or Chairperson. I can only say to you, we've made common cause on the issue itself. But I can only tell you, as an officer of the court, which of those...
No, I will not give you time when you seem not to understand me. I am saying, I'm not interested in the nitty-gritty of what falls under the Section 35 bucket. I'm not interested in that nitty-gritty. I'm looking at the broader question of, on those issues on which there is no question whatsoever, which can be dealt with by this commission, and you've agreed that there are. On those questions, why can't those questions be heard before the criminal process has been finalized? Whether, even accepting, as you argue, that there are some issues coming out of the plea deal which fall under the Section 35 basket, even accepting that, you have said there are some which do not fall under that basket, and my focus is only on those aspects that do not fall under that basket. So clearly, what you've just said about the plea deal is irrelevant to my question.
With the greatest of respect, it's not irrelevant, Chairperson, because I cannot at this point in all, as an officer of the court, distinguish between what we can answer and what we can't answer. We can only say to you, the only things...
You will never understand me. Please go on to your next point.
No, I do understand you quite clearly.
You don't.
The only issues that my client can answer, Chairperson, at this point, that we say that we form common cause on is who he doesn't know on the list of the 10-6. The rest of the issues, if I may please finish, rest of the issues, I cannot say to you, I am prepared to answer this because I don't know if I can.
I have not asked you that. You are trying to answer a question which I have not asked you. I have not asked you that question. I have simply not asked you that question. I am asking you a general question. It has nothing to do with specifics, and that general question is, on those issues on which there is no question whatsoever, those issues, I will accept for a moment, for purposes of this debate, that there are plea deal issues that fall under the Section 35 basket, and which therefore will not apply to my general question. So I'm asking you this general question again, and it is this. On those issues which even you, whether today, tomorrow, or by the end of this year, there can never ever be a question about them falling under the Section 35 basket on those issues. And again, I repeat, this is a general question. On those issues, what would the basis of us not continuing with those prior to the finalization of the criminal process? What would the basis of not doing so be?
The only basis would be that the evidence will then be presented piecemeal. I've said to you, Chairperson, and I stand by it. The only things that he can say to you at this point, I don't know A, B, C, D, and E. The rest of the issues we cannot deal with. And I, with the greatest of respect, do not think it would be in your interest for him to sit here and say, I don't know this person, I don't know this person, I don't know this person. That's the only issues that we can form common cause on that he can at this point answer. We are trying to come to the Commission and answer what we can. The problem is, and I'm sorry to repeat myself, I can only do so if I know what he can answer is shown to me in black and white. I am trying to ensure that my client comes to this Commission and gives evidence to you that is to your benefit, i.e. the work of the Commission. And not for him to be to answer things that we as legal officers, and you've been in our position before, you can never allow a client to go on oath if you as the lawyer are not sure what he said there is right. I will not perform my duty as an officer of the court if I allow that. And for that reason, right now, I can claim privilege clearly on certain issues. I can say, this is my Section 35 issues. The others, I say to you, I can't at this stage because I don't know what's going on in the background. So it might even be, once I've got the documents that I think is necessary for me to decide it, that we can move on that. But right now, we can't. And I respectfully submit that based on the remainder of the issues that we've put here, that this Commission should allow him the opportunity to finish the trial. And more so,
Again, please tell me when you are done
Yes,
responding to my question.
And then the last thing is, I think the thing that concerns me the most is, and we've taken the liberty of sharing a privileged document with you pertaining to the opinion. The one
I think that's something else then. Can I come in? Yeah.
and
when
that
you,
is, for me personally, is very concerning at this point in time.
When you referred to a piecemeal hearing, this is just for clarity, does that mean you are going back on the earlier acceptance of what I posited to you, which was, is it something that can be done for this Commission to entertain proceedings that relate to issues that have nothing to do with Section 35? And I understood you to be saying yes. But now, towards the end of your submissions, you said, I don't know, I'm paraphrasing, I'm not sure of the exact words you used, but you said something like, it wouldn't be desirable to have a piecemeal hearing, something like that.
Yes.
Is that going back on what you said earlier, which was to agree with what I posited to you?
Yes. As I said, and the reason why I say piecemeal is all that will happen at the end of the day, Chairperson, is he will sit here and say, I confirm I don't know these people. And that is literally all we can do at this point. That is the only part of the Regulation 10.6 that we are at idem with each other. I say nothing prevents him from going under oath and say, I don't know person A, B, C, D, E, and F, and sit back. The rest of the issues, again, I want to emphasize, we want to cooperate. We've put it in our paper. But give us an opportunity to ensure that what we come to the Commission with is truthful. It's based on facts.
Another thing which arises from what you said in the context of the plea deal, and if I understood you correctly, you said this in the context of dealing with why a statement was not prepared. And again, if I understood you correctly, you made the point that you or your client had to wait until that plea deal process had been finalized so as to know whatever it is that related to the facts eventually. Here's a difficulty I have. Surely facts cannot change. Facts are facts. And I do not quite get it why Mr. Matlala could not have made his statement. He knows what the facts are, regardless of what the outcome of the plea deal were to be. He knew the facts, and therefore, from where I'm sitting, subject to your response, he could have said, these are the facts, and here are my responses to the notices that I have received.
But Chairperson, the situation is
Or just to finalize, the facts could not be this or that, depending on the outcome of the plea deal. The facts are facts.
no, it is different because when people enter into plea deals, there's certain consensus reached and it goes, it's dealt with in totally different way, 105As, than what would normally, as you say, admit certain facts. If you go on a 220 or 115A and you admit facts, it's a different story. A plea deal goes beyond it. So very often, there's facts behind it. As long as that 105A stood there and the magistrate has not ruled on it, our submission is that the issues there, he could not entertain his Section 35 rights on those. He could not come to the Commission and say, listen, I'm a suspect or an accused on this particular matter, and therefore I invoke my right to silence. It's a live process, and that live process has many complex issues behind it. So for that reason alone, he could not depose to that, to any affidavit here. I understand what you're saying, Chairperson. I understand what you're saying. But if he were to honestly depose at that point before Monday to an affidavit, he had to answer questions that we believe, because of him assailing from the 105A, he now has the right to invoke a right of a constitutional right.
But the Commission's interest would be facts in accordance with what Mr. Matlala knows. And that has nothing to do with whatever it may be that informed what he said for purposes of concluding the plea deal. So on that basis, I do not follow your response.
I stand by my response, Chairperson. I cannot, again, as an officer of the court, make my client say I invoke my right here and there and wherever, when I know in law the situation is that is a live process and he cannot invoke that right at that point in time. The facts, with the greatest of respect, you say that you have to answer facts, but facts have context and facts have background. You might see something as a fact because you've got a General Mkonazi that comes and says, oh, he said A, B, and C. I come back and I can't exercise that constitutional right before you and say, whatever General Mkonazi said, he got out because the client was forced unlawfully and unconstitutionally to answer questions. He was not allowed, for instance, to have access to a lawyer. He was questioned for over 6 hours without food, etc. That surely influences that fact. Then it becomes no more a fact that we can rely on. It becomes a fact. And we know you are dealing with it as a fact because it's part of the process here. But it's a fact that was obtained unlawfully. And we have the right to make sure that you also know down the line that the facts that you rely on, General Mkonazi, for instance, say so, are not lawfully obtained facts. I can't come here and I'll say, please call so-and-so, put him in the box so I can challenge him as to how these facts that everybody now relies on were obtained. I can do that, however, because it's part and parcel of my trial that's starting on Monday.
It's exactly because there are those allegations, not only by General Mkonazi, but by many others, that the Commission wants to hear from Mr. Matlala, get his, and underline his facts. You emphasize facts coming from General Mkwanazi, and I add him and others. You emphasize those facts. What the commission is interested now is facts from Mr. Matlala. But anyway, unless you want to comment on that, Commissioner Baloyi wants to ask a question.
Chairperson, as I said, those facts are facts that General Mkwanazi rely on, that he says he obtained from my client. And we say what he relies on, you should not accept. And we can show you in due course why you shouldn't
We've not
accept. It's just
accepted
one
anything.
example.
We've not accepted anything at
No,
this
but
stage.
I'm saying to you,
Ms. Van
it's just one example.
Yeah.
If I can, unless you want to hear me.
Commissioner Baloyi has a question.
I just want to make sure that I understand what you're saying. I've understood you to say that you want access to the negotiations and the documents and everything that went on in the lead up to what would have been a plea deal that is approved by the court. And you say because you haven't had access to that, you're unable to get Mr. Matlala to respond to the notice that he has been given. Did I understand you correctly?
Indeed, because in that process that leads up, I'm sure, Commissioner, you've gone through those processes yourself. There's always deals that are made.
Your microphone is off.
Sorry, there's deals that's made. And that process to come to a finalization of a 105A involves a quid pro quo. And I need to see what the quid pro quo was.
But what does it have to do with the statement that must be submitted to the commission?
Because
Let me finish my point. That process has concluded, even if what you refer to or what you describe as the quid pro quo were to be relevant to the answers in the statement to be submitted to the commission, which I'm not saying they are, even if they were to be relevant, that process has concluded, has been declared in accordance with the law to be null and void. So for all intents and purposes, it never happened. That's what that concept means. Why is that a hurdle to Mr. Matlala submitting his statement, answering specific questions that have been put to him, and you know that in answering those questions, he's entitled to say, I don't know anything about this, if he doesn't know anything about it, and the assumption that we must make is he's going to be truthful in his responses, and if he doesn't know, that's what it is. Why are the notes and the documents that comprise or that constitute what you say is a quid pro quo, why are they relevant for our purposes?
It's highly relevant because let's speculate. I don't want to go into detail, but let's speculate for a second. In order for them to offer this deal, they sit around the table and they say to my client, we want information on A, B, C, and D. And A, B, C, and D forms part, let's say, of your list. But A, B, C, D is not part of the plea
I'm not
agreement.
interested in the nitty-gritty.
You give us this information as an example, and we will continue. We will enter into this deal with you. So, for instance, if there is, let's say, a Section 205, Section 204 affidavit opposed to, I want to see that because I want to see in that what transpired. Or what was admitted in that statement, number one. But number two, I want to see, and I feel very strongly about it, what transpired during these plea negotiations. Because in law, normally what happens, it's recorded. Because I have been quite vocal about the fact that, I'm trying to choose my words very carefully. The process that was followed, I've made it plain to you, I was not going to be involved in it because I didn't trust it. That's the 105A process. And subsequently, I'm even more concerned about the process that was followed.
I understand.
And what I'm saying to you then is, in that negotiations, names could have been mentioned, admissions could have been made, evidence or Yeah, he could have disclosed evidence to them, and
But
I
that's-
can't deal with it if I don't see what
But
happened
that's
there.
information that's within Mr. Matlala's knowledge. I don't understand, I don't quarrel with you wanting to know for your purposes. For your purposes, I don't take issue with that, so you don't need to persuade me that you want to know, you're concerned about how that process was conducted. That's not the issue. The issue that I'm raising with you is specific questions were asked of Mr. Matlala to speak to in his statement. And those issues are the issues that have been identified as relevant to our terms of reference and for our purposes. What I do not understand from you is what is the problem or what is the hurdle to Mr. Matlala answering those questions if you do not know what happened in the negotiations? Because where I'm sitting, that negotiating process has nothing to do with us. It's completely irrelevant for purposes of the commission and getting the answers that we require from Mr. Matlala. Of course, we know that Mr. Matlala has the privilege to claim self-incrimination. I will not answer this question because it will incriminate me. I have a trial coming up. We have experience in this commission about that. People have appeared and raised that, right? And we abide the law when it comes to those issues. What I don't understand in the long engagement with the chairperson that you've had is why it is that until you have received the notes and have an understanding of what happened in the quid pro quo, or what it is that was given in a process that, by the way, is null and void as matters stand, we could never, as a commission, you know that, we could never make any reference whatsoever to what happened in that process, even if we had insight into it. We don't have insight into it. We don't know what was discussed, we don't know what documents were shared, what information was shared. But even if we knew that, we could never reference that because that is an entirely separate process from our process, but that process is now null and void. So nothing that is said in that process comes before us by virtue of having been said in that process. If you accept that to be the correct position and the position of law, not just our conduct, but to be the correct position of law, you haven't said or explained why Mr. Matlala cannot submit his statement, answer the questions in whichever way he chooses, answer the questions asked of him until you've had insight into what happened between him and IDEC. The simple proposition being, he's been asked questions that are presumably within his personal knowledge, and he can give you instructions about those. And where he has no personal knowledge, he can say, I know nothing, and he'll come and tell us that. I don't understand the basis on which you are resisting. In fact, you say, I can never advise my client to answer questions. Well, it's for your client to make the decision whether to answer. Clients work on counsel's advice. It's not you who's answering questions. It's him who will tell you, this is what this question means. And you will say to him, well, that incriminates you. My advice is you don't give them that answer because it incriminates you. It's ultimately up to him to make the decision, not for counsel to say you don't answer because it incriminates. So far, you haven't said to us, Mr. Matlala refuses to answer the questions that you have given to him. You haven't said that. Your case throughout is, I need to see what was discussed with IDEC, which I say, and I say it firmly, it's completely irrelevant for purposes of your postponement and for our purposes. You keep on saying that, but in fact what you should be saying to us is Mr. Matlala refuses to submit a statement to the commission because of ABCD, then we deal with it on that basis. Thank you.
Commissioner, there's a few issues. The one thing that I've noted in the 10-6 that you, I assume, take quite seriously, there's a specific question that says, has any person tried to influence you, intimidate you, etc.? Now, you cannot say to me that that is not relevant to the Commission's work.
The answer can only be yes or no. And the rest would be the detail. If we are interested in a yes, if he says, yes, someone has tried to intimidate me, the commission may well follow up when he presents evidence and say, well, give us the detail of that intimidation. But the answer is yes or no. There's nothing, there's no privilege about it. There's absolutely, and it's a matter that is within his personal knowledge. It doesn't depend on you seeing the documents from IDEC. It's an answer that Mr. Matlala is in a position to give to you. So it's a bad example that you're choosing.
No, I respectfully disagree with you, because if there are, if for instance there's intimidation, or for instance if there's undue influence, with the greatest respect, I've come across, and I've got no problem that you yourself have come across people that do not understand that what they are subjected to is undue influence to get to a point. So I stand by my answer previously. The other issue that I want to raise with you is, as a litigator, we've got ethical obligations when we deal with clients to ensure, and you're right, I advise my client, that is my duty. But I do not know of a single attorney or an advocate in this country that will allow their client to depose to an affidavit if they're not satisfied that what is in that affidavit is correct. We all do this. We do litigation, we run trials. That is our ethical obligation. And if the issue is then that I am obstructing the process, if I want to put obstructed in inverted commas, by insisting on making sure that what I have is correct, then blame me. Don't blame my client, because I believe that in acting as I am, I'm carrying out my ethical obligations. I've been doing this for long enough, so have you, to know things are not black and white. There's a vast grey area in between. And I want my client to come and assist the commission, but I want him at the end of the day to do so free of anybody coming and saying, you're committing perjury because we've got something to the contrary. I want him to come here without later on falling foul of a previous inconsistent statement. It's my job to make sure that that doesn't happen.
Can I ask you this question just to make sure that I understand your position? Is your position, and Mr. Matlala, when I say your, I really mean Mr. Matlala because he's the client, is your position that until you receive the material from IDEC that you say you need to see, what was given, what was offered, until you receive that, this commission will never receive a statement from Mr. Matlala and he will never testify? Is that what you're saying?
No, that's not what I said.
Then what is the relevance of the IDEC background material in a process that has been declared null and void?
Maybe I must just go one step further and say that I have discussed with my learned friend, and I actually didn't want to go there, that we can sit down at some stage and try and work out some of these issues. But I'm saying to the Commission that all we want is we want an opportunity to comply with the 10.6. I've never said we're not going to comply with that. We want an opportunity to do so. The second issue is, and I want to almost...
Sorry, what is the opportunity? I think...
I want to postpone it.
I want to make sure that we understand what it is you are seeking from us commissioners. When you say, you are not saying that until you've received the IDEC material, Mr. Matlala can never submit a statement and he can never testify. You're saying that's not your position.
My position is not, it doesn't only relate to IDEC. Can we just go one step further?
Let's take it one step
It doesn't
further.
only, but let me just go. No, it's on.
Thank you.
It goes further. The Commission is in possession of recordings that was only disclosed to us. So
No, hold on.
further.
No, hold on. I want us to do one step at a time so that we tick off what is the issue. If we've resolved an issue, we both agree this is off the table now. Now we are going to a different topic. I know that in your affidavit you do speak to recordings and transcripts. We will still get there. You haven't engaged with that. I just want to be clear, because my understanding from the time when you were engaging with the chairperson, and hence my questions that I've asked of you, my understanding of your position was, and still continues to be, that until you have received from IDEC, whenever that will be, if they will ever give you that material, until that point that you've received that material, Mr. Matlala can never depose to a statement, because you would not let your client depose to an affidavit where in future he gets met with previous inconsistent statements and all of that. So I ask the question so that there's absolute clarity about what it is that we are dealing with. Is your position, let me repeat, is the position that you are adopting that until you have received the IDEC material that led to the now collapsed plea deal, Mr. Matlala will not be in a position to file a statement to the Commission, and Mr. Matlala is not in a position to testify before the Commission?
Chairperson, of course, that is my position at this point in time, because I'm ethically bound to act in that manner. Again, I say to you, I cannot think of any other council that would act differently than I do. So, but
Yes.
This is not an impediment, because I truly believe we can get the information relatively quickly. So I'm saying to you, please just take into account, this plea deal collapsed on Monday. It's Wednesday. So we've got this very short period. But that's not the only thing that I say.
No, don't go to the other things.
Right.
I'm more interested in the question of principle. I want to establish the principle. It's important to us. If by the time we finish here, you rise and your position is until he has received the IDEC material, or you have received the IDEC material, whenever that will be, maybe tomorrow, maybe day after tomorrow, maybe next year, maybe not ever. I want to establish the principle to make sure I understand the principal position. Is the principal position that until you have received and considered, as his counsel or his legal team, until you've received and considered the IDEC material, Mr. Matlala will not file a statement and he will not testify? Is that the position you are conveying to us?
Until such time I am told by any person in the legal profession that I'm wrong in going to a point where I say part of what I'm doing here is to protect my client's rights. I stand by that.
Yeah,
I
Ms.
say it is
No, I
I
must insist, Ms. van der Heever, I've asked a direct question. Let's stop this going around. I'm not asking you about being advised by somebody, being told you're right or wrong. And I haven't yet expressed a view that you're wrong, by the way. I'm not saying your position is wrong, right? I'm still at the point where I want to understand the position. And it is a yes or no kind of question. You have motivated, you have argued, and you don't need to do that any further. I'm now at a point where I want to understand, is the position that until you have the IDEC material, Mr. Matlala will not file a statement and Mr. Matlala will not testify? The answer is a yes or no.
My instructions are that we will file a statement as soon as possible.
What is your answer to my question?
I've told you, Commissioner.
So you will file a statement even if you do not have the IDEC
That is
material?
my instructions at this
Okay,
point.
that you will file the
I got
statement.
instructions from my attorney to deal with it in
Thank
that
you,
regard.
thank you.
May I just, before Commissioner Kumalo asks a question, he says his point is now covered.
Okay.
You said earlier you had a discussion about timelines or the timing. I just want to find out at this stage, before you continue with the rest of your submissions, to find out by when the statement that you say can be filed, by when will that be filed?
Chairperson, I've not
I know perhaps
arranged
it's
for
something,
yeah,
it's something you may want to engage Ms. Silo about, but I would just like to hear from you.
May I take an instruction just for
Yes, yes.
We think we can do it in 2 weeks. Of course, please take into account we're starting a trial on Monday. And that is, of course, also premised on the fact that we get the recordings that's been referred to and relied on by certain witnesses in the commission. And I've discussed another issue with my learned friend, but I'm not going to deal with this on the record. Me and her have managed so far to, between us, sort these issues out. So if it's convenient and if so permitted by the commission, my attorney says that we can probably do that in the next 2 weeks. Because, of course, maybe just for the record, we can also obtain some of the information through the erstwhile attorney. So.
On this and possibly any other issues that may require discussion between you and your colleague, Ms. van den Heever, we'll give you time, so we will adjourn before any ruling is made. But I don't think you were done with your submissions unless you tell us that you are. If not, you may continue.
I think my submissions are quite clear pertaining to the upcoming trial. I think we have the right to be presumed innocent. This commission is watched by many, many people, and I'm just afraid, as it goes, the questioning of him, and I'm not necessarily saying by yourselves, but I know my learned friend might give the perception that he's guilty, and he will go into his trial with baggage, and I'm trying to prevent that. I've set out for you, I think, quite clear the issues that we are dealing with. And then, of course, I'm asking you to pay serious consideration to what is contained in the opinion that we've urgently obtained for you, because I find it very persuading. I hope you do too. And we are endeavoring to deal with that issues the best we can. Thank you very much. Sorry, Chairperson, my attorney has just asked me to emphasize the point that part of the delay had to do with the recordings that was not given to us, and which is quite important.
I'll give you an opportunity. You just... Ms. van den Heever, we heard what you say, and what you said you wanted to emphasize, unless you want to add to that.
Just been asked by the attorney to emphasize the point. Those recordings are vital. They've been referred to by witnesses. They've been, and the day we received the recording, and I thank my learned friend for her intervention in that, was the very day that the statement was due. As you can imagine, we've got limited access to the client. I personally had to phone the head of CMAX to ask, please, can the attorney go in? And he's not even finished listening to the recording. So it's also impeded quite a bit of the issues at yes. And then lastly, maybe I should also emphasize that you please take into account, Commissioners, that whilst this process of the 105 was unfolding, we were not part of it. We couldn't get instructions on it because somebody else was dealing with it. So even if we wanted to, we were basically, and I say this respectfully, cut off from dealing with the issue for other reasons that I assume will at some stage come to light here. Thank you very much.
Thank you, Ms. Van den Heever. Ms. Sello.
Thank you, Chair. Chair, I have a witness whose testimony was deferred to later in the morning, and I'm quite mindful of that witness. So that constrains me significantly as to how I respond. So I will try to be as brief as possible, and in so doing, perhaps to assist the commissioners. I would like to start with where my learned friend ended, which is an offer to file the statement in 2 weeks. That effectively takes care of the first part of the ruling, or was it the second part, but one part of the ruling of the 7th to file in 2 weeks. We have spent over an hour engaging, my learned friend engaging you on matters that don't get to that conclusion. That's where she ought to have started and would have saved significant amount of time. I say this because on reading the affidavit in support of the application for postponement, one must bear in mind that we appeared before you on the 7th of July. Everything that is in that affidavit predates our appearance. And it is at that appearance, notwithstanding the facts as asserted in that affidavit, an undertaking was made. So if those facts were not relevant prior to the 7th, and the very facts, notwithstanding the very facts, they were able to make specific undertakings, which included filing by the 8th of July and appearing on the 15th, I truly do not understand how then they become relevant come the 15th. They revive, they suddenly become relevant. The challenge with this application is nothing in the affidavit speaks to the period between the 7th and the 15th. Nothing happened that even threatened the undertaking made to you on the 7th, Chair. So the question is, why must I entertain this entire argument if not to waste the Commission's time? Mr. Matlala's legal representatives were informed by certain facts to conclude that they're in a position to make certain undertakings on his behalf. They don't come here and say, those facts have changed. They don't come here and say, since the undertaking was made, new facts have come to light that make it impossible for us to comply. So technically, that undertaking made is not worth the paper it's written on. And this is a complete waste of the Commission's time.
Can you,
Now,
sorry,
yes.
Mr. Lo. Can you please make me understand something Ms. Van den Heever said on the 7th?
Yes, Chair.
Ms. Van den Heever indicated that she was agreeing to the filing
Yes.
by the deadline that was indicated, something like subject to the reservation of Mr. Matlala's rights. Even as she said that, I wasn't sure in my mind what exactly that meant. What was your understanding?
My understanding...
Of course, maybe I should have
subject.
asked, I should have put that question to Ms. Van den Heever.
It's a subject, of course, to Ms. Van den Heever confirming,
Yeah.
but I had understood that the proviso was file on the 8th, subject to Mr. Matlala's right to supplement statement filed. That was the reservation made.
Because there could not be an undertaking to file, but at the same time not to file, an undertaking
yes.
not to file.
And in fact,
It's even
that-
wrong, it's even wrong for me to refer to the latter as an undertaking, yeah.
And in fact, that proviso was discussed amongst ourselves because of the tight timeline they then had to file by, having missed previous deadlines. The only way to cure any potential prejudice to Mr. Matlala was to agree and place on record that he reserves the right to supplement. We thought it is a natural way to go, and he's entitled to supplement whether or not he has reserved that right in any event. But to the extent that it was necessary to articulate it in no uncertain terms, we were agreed to that. So that was the proviso, Chair, that was attached
All right,
to the filing.
please continue.
Thank you. So at the end of the day, what the legal position is regarding Mr. Matlala's constitutional rights, as posited by Leonard Friend, is irrelevant for our purposes. She may very well be correct, she may very well be wrong, but it doesn't advance the issue any further. Those rights existed on the 7th when she made the undertaking, unless she suggests that they have since or very recently been earned. I listen carefully and I resist the urge to argue that this is a moving target. And each time we think we've got the target, then that target is going to move. And we are continuously chasing a rabbit we cannot catch. And Chair, I implore you and commissioners to please put an end to this. Witnesses come here and make undertakings. They give dates. We work on a very tight time schedule. Either witnesses respect the rulings given by the commission and adhere to those rulings and file, or either appear on the dates that have been either directed by the commissioners or on which they have made undertakings, because otherwise it makes the work of the commission impossible. We now have to change things about. We now have to find another slot for Mr. Matlala. We now have to plan for him when to give an affidavit, a statement, and to find a slot. And all this time, it's in circumstances where this commission has got a limited time span left to it. I am concerned about the approach being adopted by Mr. Matlala's representatives, and I don't think it is particularly appreciative of the challenges that the commission faces. As to whether or not the commissioners and the chair will permit the rulings handed down to be wantonly disregarded, as for the commissioners to decide. But I wouldn't be surprised if the commission holds a dim view of that. So, the difficulty we have, or I have personally, listening, is, and I do accept that I possibly misunderstand Ms. van der Heever. The plea agreement with IDEC, the aborted or stillborn plea agreement with IDEC, at the risk of stating the obvious, that has got absolutely nothing to do with this commission. What this commission is interested in is its terms of reference. It's interested in the issues that were raised in the Rule 3 notice that was served on Mr. Matlala, as well as the subsequent Regulation 10.6 notice. That's all where this commission is interested in. I'll rephrase that. That is all the evidence leaders have indicated they are interested in. The commissioners may expand those issues. What position Mr. Matlala assumes in response thereto is his choice. We desperately do not want to be a part of a discussion on how does he respond to a particular question. If a question posed invites a defense, a Section 35 of the Constitution defense, so he must state, and then we will deal with the defense as raised when he appears.
And as I put it to Ms. van der Heever, it cannot be that everything he could ever say is covered by or by Section 35.
Indeed.
Or bears relevance to the Section 35 protection. It can never be, and Ms. van der Heever accepted that.
Yes, Chair.
And facts are facts, and they should not change in accordance with whatever it was that went on under the plea deal. But as Commissioner Baloyi said, that's null and void anyway.
In any event. And once again, it depends on whether I understood her correctly. It gets worse because now it sounds like the commission shall be hamstrung by any plea deal that Mr. Matlala may choose in any criminal trial, whether ongoing or in the future, to conclude. So, effectively, if Mr. Matlala were to tomorrow face 5 charges in five different criminal trials, and he considers whether or not to conclude a plea deal in any one of them, then this commission is hamstrung, unless I completely misunderstood Ms. van der Heever. My understanding would be, I don't believe she would suggest that. But at the same time, then I struggle, what exactly is being suggested regarding these plea deals? And once again, I have no clarity. I submit, commissioners, that the only position to assume is we have nothing to do with any plea deals that Mr. Matlala chooses to conclude anywhere in any court. He has 2 defenses in this commission. It's a Section 35 defense, or buttressed, in fact, by Section 8, sub 2 of the Commissions Act, that anything he says that would incriminate him cannot be used against him in any criminal case. So he's got 2. He can raise them. So why we are having a debate about plea deals and whether or not his legal team understands the facts that underpin such a plea deal is a challenge to me. Now, the offer, mindful of the time, made to file in 2 weeks, I can accept. In any event, it's up to the commissioners. However, the offer, if I understand it correctly, sounds to be conditional, and this is what the condition is. It's dependent on whether or not they get the requested information from either IDEC to enable them to answer the questions posed. If I misunderstood, because I think Commissioner Baloyi indicates there's shaking her head as if I misunderstood her.
I think the ultimate position was they will file a statement.
If it is wholly unconditional by a specified date, then I'm happy. Because my concern was that if they do not get the required information from IDEC, or IDEC just outright refuses, then they would be entitled in law to approach a court to compel IDEC to provide such information if they have a basis in law to do so. And if that court case is unfavorable to them, there are appeal proceedings. So the question would be, do we await that information and the challenge to right to that information to run its course until the Constitutional Court before we get a statement? But I will accept what Commissioner Baloyi says the filing in 2 weeks is unconditional. If that is the case, then we just need to set a date. And if the statement is not filed, we shall be back before you, Chair. And I suggest that the consequences will follow. What then must happen now is to lock in a date, as we did of the 15th that has now collapsed, as to when Mr. Matlala will appear. And I say so because we as the evidence leaders have to go rejig our program and accommodate the new dates, while at the same time making sure that there is sufficient time for everybody to prepare for Mr. Matlala's appearance before you.
Would the preference be for the postponement to be to a specific date or a date to be determined?
No, Chair, I would prefer a specific date at this point.
Specific, all
Yes.
right. All right, please continue then.
Thank you, Chair. And to assist perhaps the commissioners to consider a possible date, my learned friend will confirm, I understood that the upcoming trial that starts on the 20th.
Just a minute.
Yes, Chair.
I think on your last point about the date, I think it would be better for you and Ms. Vanenhoefer to engage, and then, which of course would necessitate a stand down. And when we come back, hopefully, we'll get an agreed date.
Oh, no, I'm happy with that approach,
yes.
as long as I come out of this hearing with a ruling on a date, Chair. However that point is reached is irrelevant. I'll accept that, Chair.
Any further submissions?
No, Chair, I think that will suffice. I'm looking at the time. As the commissioners are aware, there's another administrative issue to deal with before my witness returns to complete his testimony.
Any reply, Ms. Vanenhoefer?
I'm going to be very brief, Chairperson.
Yes.
I'm not going to go back to the issues of the plea deal. I've got experience in that regard, and I know it's important. And at some point in time, I will demonstrate to you what the importance of that is.
Yes.
The second thing, my learned friend says that subsequent to the date of the 7th, nothing happened. The affidavit sets out quite clearly what happened subsequent to the 7th. The 13th, we were back in court. There's also the issue on the 8th, the recordings were disclosed and what happened there. So my learned friend is not correct when she says there's nothing. It's been set out chapter and verse what transpired from that date on. And the thing that's quite important, Chairperson, is I don't believe this commission, and I've said it before, as you recall, we're not here to ambush witnesses. And it's for that reason that I'm entitled to ask, if you're in possession of certain material that you wish to use against my client, I'm entitled to ask for it. Because that way we level the playing field. So that also needs to be taken into account. Lastly, you were quite right. I did reserve my right twice.
Or just before you move to a different point, wasn't everything that Mr. Matlala required given before the 7th of July?
We said that there must be certain recordings. We then given 13 voice files. We then said it's clear somebody went and extracted, like cherry picked and given us 7 voice files. We now want the complete recordings from which these were extracted. We were then given on the 8th, I think, recordings, 2 recordings. There's in fact a 3rd recording that was not given to us. Then we were handed over, I discussed it with my learned friend, and she made some inquiries. We were given a transcript, an unofficial transcript of the one. So, and these are long. The one is 6 hours, and the others together is longer than that. So, and the client must sit and listen to it because he needs to ensure himself. So that process wasn't even concluded. And then lastly, as I said, it's just an issue of, I did reserve my right because I foresaw what was going to happen at that point in time. It was not a condition I will file and then amplify. I just couldn't because at that point I still hadn't had any access to the client to discuss any of the issues relating to, as I said, let's call it the Medicare 24 matter. One more thing, Chairperson, I'm going to ask you and the commissioners to consider the following. I'm going to ask that we be assisted and that an order is made that we get access to the client over weekends with electronic devices, in other words, with the computers, to assist us in dealing with all of these things. It's very difficult if we can't do that. It's the times that you can see the client is limited. There's only a limited number of legal practitioners at any given time that can see the person. And if you were to see in the normal way, there's a thick glass and you can't listen to recordings. So we would like, if there's any way that you see open, that we be allowed for this weekend and the next weekend to get access. After that, we won't need it because the last weekend would be just before the filing. Because we're also starting on Monday, he gets transported, very limited time in court because we're running the trial. So what we can do is we can get drafts exchanged that he can look at that, but to finalize it, we'll also need to have access to him next weekend at the prison.
How is it done for purposes of the criminal trial that's commencing? Is it next week?
We've had consultations long before. It's actually a much simpler matter than anybody has made it out to be. And that's why for that it was easy. We've given the client the dockets that was disclosed, and when we had opportunities, we've discussed with him our defense, our police. So that was, and we had two person-to-person meetings that was allowed by the head of the unit. So we could actually go in with computers and have those. But for some reason, I think because of what has been transpired, we are not getting access that easily anymore. I can just speculate why suddenly, after things have started going a bit differently. So all I'm asking is if you can assist us in that regard, we'd appreciate it.
Yeah, I think something like that would have to be dealt with administratively. I cannot make a ruling here. But anyway, it's not that I understood you to be asking for a ruling. Because, for example, I do not know what prescripts correctional services may put up and say, we can't comply.
No, so all I'm basically asking,
but that should never be understood to say, after agreement on a date, what happens or does not happen will then be a basis for saying, no, we are not able to file because. Please continue if there are further submissions.
Simple, we will do our best, but maybe something from the Commission side that we should, without making a ruling, that from DCS side, that they should do whatever they can to assist us. I think that would go a long way. That would give us something in the hand to now go and do from our side what we need to do. Thank you. I've got nothing else.
Nothing else.
I agree with my learned friend then that we discuss inter partes the date.
Yes, all right.
Ms. van der Heever, without getting into it, I just want to know its status. The opinion letter, I'm not getting into it. Was it filed just for the purpose of today's postponement? It was to deal with just today.
Oops, it doesn't work anymore. Oh, there it goes. It was done for today because of, as I said, that's all I wanted to say.
Yeah, it doesn't go beyond.
There are other reports and things that's been drafted. We have been communicating with the head of prison with regard to the issues, but I don't want to go into that further at this point in time.
It was just for today's postponement.
For
That's
today,
all I
and
wanted
the relevant part of it, you'll find about the issue of. Yeah, I mean, you've read it.
Leave it there. That's fine. Thank you, Mansard.
Chair, if I may, for the record, to correct for the record and posterity, Ms. van der Heever speaks of being provided with random extractions from recordings. That's wholly incorrect. The recordings that were provided were recordings that were played in this commission during the testimonies of witnesses. As we do when we provide our Rule 3s, we provide the evidence that implicates the particular witness who served with a Rule 3. Those are the 13 recordings that were played in here. They were not random. Nobody went into the recordings and decided they liked the sound of the clipping from 1 hour 15 to 1 hour 17 minutes. So that is one. Those were provided on the 18th of June. They were given to Mr. Matlala. It is only on the 7th of July, after the ruling, and their statement is due the next day on the 8th, that they require the complete recordings. And they were duly provided on the 8th. So it is not like information was denied them or we failed to respond positively to any request for information made. Each time it is made, it is given. The inescapable conclusion is nobody listened to those 13 clippings when they were provided, and therefore, because if they did, they would have made the determination at that time already that they require full clippings in order to prepare a statement. Thank you, Chair.
Maybe that just on that issue, Chairperson, what we immediately on receiving those recordings send it off to an official transcriber. It was in vernacular. It then had to be typed up and then transcribed. And then upon seeing the client with the computer, it's only then that we realized that these were extracts from various other recordings. And it was only at that point that we could approach the commission, the evidence leader, my learned friend, and say we want the full recordings, because we were then informed that it's extracts from other recordings.
We will, thank you to both of you. We will, let me just look at the time. We will adjourn and come back when you tell us to, and we hope that we'll be within a very short time. We are not taking the tea break at this stage.
Noted, Chair.
And this is for a discussion between the two of you on the date of the hearing, and two, the date of the filing of Mr. Matlala's statement.
Thank you, Chair.
Let's adjourn.
Devices are quiet, put them on silent. Thank you.
In hindsight, I think we should have taken the tea break because we are going to lose a lot of time now. Yeah, instead of hanging around outside, which is what we did. Anyway, let me hear from both council.
Thank you, Chair. I agree with you. Perhaps we might as well have taken a tea break. It took, the negotiated settlement took longer than we had anticipated, but we think we found each other. So this is the agreement we have reached going forward, and we would request a ruling be made in that regard, that Mr. Matlala's statement shall be filed on or before the 29th of July 2026, and that his testimony is stood down to starting the 1st of September 2026. So the hearing will commence on the 1st, and depending on the issues that we have to engage with, that could run into subsequent days. We would request that we do not commit to specific dates thereafter, but there's an appreciation that we are not fixing one day of the 1st. It's from the 1st. Thank you. Thank you, Chair.
Ms. Lo, is it the understanding between you and Ms. van den Heever that if we need to roll over to the next day, we won't run into diary issues that Ms. van Heeren had not prepared for that?
Exactly, Commissioner Baloyi, and hence I express his date of appearance as from the 1st. So the agreement is the 1st and succeeding days as much as are required in that week. But I don't want to give, I won't say the 1st to the 4th, it could very well be, but we start on the 1st until he concludes his testimony, uninterrupted. Thank you.
Thank you.
Chairperson, I indeed confirm that that is the agreement. My understanding is that we start on the 1st and then it will continue until such time as we've reached the end. If I may just use an opportunity to just deal with one issue. I got a random message from somebody on my phone telling me that I'm not allowed to shout at you, Chairperson, or the other commissioners. I just want to make it plain that I don't shout, I just speak very loudly. Most people know that. So I am sure you didn't perceive it as shouting, neither yourself nor the other commissioners I spoke to. Just for people that don't know me, I speak very loudly. It's not shouting. Thank you very much, Chairperson.
If it gives you any comfort, Ms. van den Heever, let me tell you that a judge, when I was appearing in the Mthatha High Court, once shouted at me saying I should not shout at him. So
Then we're in the same boat, Chairperson. I'm very happy to hear that. Thank you.
thank you. Oh, one other thing, at least based on the agreement that has just been conveyed to me, I assume that you will not be insisting on reasons for the fact that we are saying the hearing will be continuing.
I do not need
Thank
any
you.
reasons. May it please you. Thank you.
Thank you, thank you. I thought I should just take care of that because there was the muted reference to the possibility of a High Court application. So one might say no reasons were ever given for an application that we made.
Like they say, I don't roll that way, Chairperson.
Thank you. I make the following ruling. Mr. Matlala must file his statement not later than 29 July 2026. And that's one. Two, the hearing of his testimony is postponed to 1 September 2026 to continue until the hearing has been finalized.
Thank you very much, Chairperson.
Thank you.
Thank you, Chair.
Thank you. Mr. Matlala, Ms. van den Heever, you are excused. And because we are continuing with you, Ms. Sillo, you are not excused.
Chair,
Is it?
it's not with
Oh,
me
for
for the
later.
next admin issue, yes. So only thereafter I come
Still
back.
you are with us, later in the day, of course.
Yes,
But
thank
thank you. Let's adjourn and come back at midday, 12.
Thank you, Chair.